Question is that the bill be now read a second time. Mr. Yip Hon Weng.
Mr. Speaker, sir, debt collection activity is often a necessary and important part of any credit ecosystem. But debt collection must be performed in a regulated and civil manner. The number of police reports made against debt collection harassment has remained high in recent years. Licensing debt collecting companies is a step in the right direction. This is to stamp out problematic debt collection activities. Nevertheless, I wish to seek some clarifications. First, Mr. Speaker, sir, are there specific offences that are given more weight when taken into consideration in approving the license of debt collectors? I understand that a range of offences under the Organised Crime Act, Vandalism Act, and Protection from Harassment Act will be given more weight against the approval of license. Is this an exhaustive list? Would the licensing officer also take into consideration the age of the debt collector at the time of the offence, the frequency of the offences, and the interval between the last offence and the time of license application? Second, Mr. Speaker, sir, there must be clearer and accessible guidelines on what constitutes proper and improper debt collection. This is not merely for the benefit of the licensed debt collectors. It also benefits potential victims of improper licensed debt collectors. There was a very recent case of a resident who started with legitimate intentions to get a $30,000 loan from a purportedly licensed moneylender. However, she ended up losing even more cash in a loan scam. She also got harassed by loan sharks and even got duped into being a money mule. As such, having clear guidelines would help residents not fall prey to dubious debt collectors. Another area of concern is the coverage of communication channels. Does the bill cover online correspondences such as email, social media platforms, and instant messaging apps? These channels have become increasingly common means for debt collectors to badger the debtor. So much so that the USA's Consumer Financial Protection Bureau had in 2021 approved a set of rules which dictate how debt collection agencies can email, text, or contact debtors on social media to seek repayment of unpaid debts. Among these rules, collectors must allow debtors to opt out of being contacted online. Any messages that they send also have to be private. They are not allowed to post on the debtor's social media pages if it is public or visible to contacts. Are there plans to adopt similar rules here in Singapore? I also wish to ask, how does the bill apply to the guarantors of debtors? I support the move to disallow debt collectors to collect money or attempt to contact persons who are not the direct debtors. However, can the minister clarify whether this is also extended to guarantors of the debtor? Are guarantors bound by law to repay the debts on behalf of the debtor? Some people may have involuntarily agreed to become guarantors without expecting to be responsible for the loan. This could happen where the guarantor did not have full understanding of the implications, or they did it out of friendship or family obligations. Does the bill deem guarantors to also be debtors? Would the ministry also consider enhanced penalties for debt collectors who harass family members or other persons? Clear guidelines have to be followed through with compliance. Clause 16 of the bill mentions that the licensing officer sets out the code of practice. How will this code of practice be determined, and how will compliance be enforced? Should debt collectors be required to wear body cameras? Do they also have to produce their license to the targeted debtor before embarking on their debt collecting activities? Third, Mr. Speaker, sir, we also want to ensure that the guidelines and regulations are not too restrictive to the point of hampering legitimate debt collection work. There is some concern that under the new licensing, with a list of guidelines on what debt collectors cannot do, the pendulum may have swung to the other extreme. In order to reduce the ambiguity of what constitutes improper debt collection, would the code of practice to be introduced via Clause 16 of the bill provide a list of best practices and guidelines with relevant explanatory notes on what debt collectors can or cannot do. In Australia, the relevant government and public agencies worked on a debt collection guideline for collectors and creditors. Its purpose is to assist creditors, collectors, and debtors to understand their rights and obligations. It is also to ensure that debt collection activity is consistent with consumer protection laws. Do we intend to send out similar guidelines? If a debt collector is found to have breached the regulations, what are the avenues for victims to lodge a complaint? Should a specific hotline or body be created to address these complaints? My concern is that finite resources of the police may be clogged up by such complaints, which are often less urgent. What action will be taken against the collector? Will they be suspended pending investigation? How do we avoid situations when a recalcitrant debtor makes frivolous complaints to hamper the debt collector's work job and avoid paying the debts? Who will manage and investigate the complaints? Will it be the police or the licensing officer? Fourthly, Mr. Speaker, sir, how are licensing officers selected? The police and licensing officers have a significant role to play in enforcing the regulations of the bill. Debt collectors are screened by the police, and debt collecting companies are licensed by licensing officers. Can the ministry clarify whether licensing officers are recruited from the police, or would they belong to another department under the ministry? Finally, Mr. Speaker, sir, I would like to share 2 points on reducing the need for aggressive debt collecting. First, we should limit the over-incentivizing of debt collection companies. I'm concerned that some of these companies, especially those that are paid on a commission basis, may resort to hard-handed measures to collect debt. Especially, it means that they earn more in return. Will the ministry consider implementing a cap on the total amount of incentives that a debt collection company can earn from a particular assignment? Are clients of debt collection agencies required to pay a base compensation to these agencies, even if the agency fails to achieve the target? More importantly, we should strive to solve the problem upstream by reducing the incidence of overdue debts. This will require more public education about borrowing money from different types of sources, be they individuals or licensed moneylenders. Companies in the business of providing loan should always impose credit checks before granting loans. This is to prevent debtors from over-leveraging. Debtors, too, are responsible for learning and practicing good financial management. This is to ensure that they can repay their debts in a timely manner. They should also be aware of their legal rights pertaining to overdue payments and debt collection laws. Are our community legal clinics adequately equipped to help residents who have relevant concerns? In conclusion, Mr. Speaker, sir, I have spoken to some residents who have shared with me about their experiences with debt collectors. They shared that the way some of these debt collection agencies work is no different from how some loan sharks or alongs operate. Some have no qualms about using tactics such as public intimidation, shaming using vulgarities, and sometimes even using violence to get the work done. As we move Singapore forward, we absolutely cannot condone any individual or organization to harass or harm someone, even if it is done with the objective of fulfilling their job responsibilities. Any eventual failure to reclaim debts should be resolved through legal means. I'm confident that the new laws will greatly reduce the number of harassment cases and in doing so, help build a more safe and secure Singapore. I support the bill. Thank you.